Corporate law. Corporations have been around since, I believe, around the early 1500s. Corporations, we think of them as commonplace nowadays, but back in the 1500s to the 1700s, they would have been quite rare. The king and the Pope would sometimes incorporate a body that would become an entity, and then the entity could go and do some things. As we talked at the beginning of partnership law, it's sort of a big deal that a new entity can be formed, and that new entity can have some rights and do some things, can own property, the entity can be sued, the entity can take out a loan, the entity can hold money, the entity is sort of a new person. So that was a new concept, and it was a special concept back in the 1500s, 1700s, that time period. Well, there was a corporation that did very well, made a lot of money. It's totally escaping my mind, but it's in tons of movies out there. That's, of course, where I know it from. Currently watching The Terror on AMC. I feel like that corporation will be mentioned on there. I am totally rambling. I apologize. Anyways, well, we had one of our first financial crises of the modern age. A modern age financial crisis occurred as this first corporation made lots of money. The investors became super wealthy, pennies on the dollar, that type of thing. And so the Crown said, we need to make more corporations because corporations are doing so well and making people so wealthy. And so more corporations came to be formed, and those corporations be more or less successful, but still people were getting this fervor for the money that could be made inside of corporations back then. So you had all kinds of people investing into corporations. And so what happens? Well, of course, people begin to take advantage of the fact that there's not any protections in the laws, and these fraudulent things can be going along kind of like Ponzi schemes, that kind of stuff, where they can be promising the world, we're going to go find lost treasure and please invest in us, and we're going to go find the lost city of gold, whatever, and they make all this money and they just abscond with it because they have no corporate or fiduciary duties, and there's a giant crash as the value of these corporations tank, as everyone's trying to pull their money out as they realize that many of these corporations are scam and run by individuals that are just attempting to rob others through fraud. So that was the first financial bubble that burst, and then the English Parliament successfully enacted the Bubble Act that curbed the formation of corporations, and then it's taken us hundreds of years to get to this point now where corporations are commonplace every day, plenty of laws out there to keep people acting appropriately inside of their corporate structure. Corporate attributes. Corporations need to be formed. We talked about partnerships being formed. Partnerships can be formed quite easily. I go up, I say, hey, let's go make some money in this project, painting some houses. It'll be great. Boom, partnership happens. Well, partnerships are easy to form. Creating a corporation is more complicated because you need some formal documents to be drafted out, drawn up, agreed to, and signed, and then they must be placed on file somewhere with some type of public authority. In the United States, it's going to be with some type of state authority. Control. In a partnership, all general partners have equal rights in management and conduct of the business unless they're going to agree otherwise. And in a corporation, there's two different types. Really, you have the small corporation and you have the large corporation. That's the way I would think of them. The small corporation can be closely held. Closely held means there's going to be very few members or shareholders. 1, 2, 3 is an easy number to conceive of. Individuals that are in a corporation, for instance, my dad and I, we own some laundromats, and we are both shareholders. We hold these laundromats in sub-S corporations. That would be an example of a closely held entity. The opposite of, well, I don't know if opposite's the correct term, but the other type of corporation you have is the publicly held entity. That would be the General Motors, the McDonald's. I want to say Chipotle for some reason. I'm just going to keep doing food at this point. What do we got? We got Rallies, TGI Fridays. I don't know how many of these are publicly held corporations. But anyways, General Motors, that's a great example. There you're going to have, I'm totally rambling here. I apologize. All I'm drinking is lemon water, by the way, in case you're wondering. And a closely held corporation, because there's a few number of shareholders, those shareholders are going to have a great amount of influence upon how the business is run, who are the directors, who are the officers, who are the employees. In a closely held corporation, shareholders, because they own a majority of the stock, are going to have more influence over the corporation, whereas in the publicly held corporation, I can own 100 shares of General Motors stock, and I'm not getting anything done all by my lonesome in regards to who a director is going to be or if some employee should be hired or fired because I own 100 shares of General Motors stock. In a publicly held corporation, low amount of influence unless you would own a large volume of percentage of stock. Transferability is another corporate attribute. Transferability of interest in a partnership is a problem because a transferee cannot become a member unless all partners consent. Also, when we're talking about a corporation, those stocks that you own are going to have rules of transferability. Now, in a publicly held corporation, it's going to be relatively simple. You're going to be allowed to transfer your stock. You're going to call up your Edward Jones. Or you're going to log in. You're going to call up. Anyways, you're going to log into your account. You're going to sell some shares of General Motors, right? It's going to be quite easy to accomplish. But now in a closely held corporation, typically there are way more restrictions on a stock sale. Of course, so if my dad would like to retire and wants to sell his stocks to someone else, it might be a person that I really don't want to do business with. I don't trust them, etc. I don't know who they are. Therefore, we're going to have some restrictions where there needs to be some agreements and things like that in order for one of us to be able to transfer the stock. And that's because in a closely held corporation, things are going to happen differently than in a publicly held corporation. Some other corporate attributes, we have taxation. We've talked about that before. In a limited liability company or in a partnership, that income that the business generates is going to pass through, be allocated to those members, those partners, and that's going to go right on their tax return, and they're going to be paying taxes. Well, how does it work for sub S corporations or C corporations? In a sub S corporation, the money is still going to pass through the entity in some way. Well, let me break this up here. In a sub S corporation, you're going to be a shareholder and you will be paid dividends. And so that's it's a different form of payment, but it still is going to be taxed very similarly to an LLC, that payment that is funneled through the corporation to the sub S member, but there are some tax advantages because of it coming out in that corporate form of payment. You typically don't need to pay so much in Social Security and Medicare and things like that. So there are some tax advantages being in a sub S corporation versus an LLC. Now, there's some formalities there because in an LLC you can be a member and kind of la-di-da do your thing, and you can be sort of a shareholder and really not do anything on the side, or you can be more of a manager of the corporation. Either way, it's a pass-through entity. The money's coming in to you. But now in the sub S corporation, you still need someone that is managing the corporation. As soon as you're doing something other than being that investor, that shareholder, you are actually taking in some type of active role in the corporation. You then need a salary in the sub S corporation. And once you're getting a salary, you are then an employee. And as an employee, you got to pay unemployment, workers' compensation, you have to pay Social Security, Medicare, those types of things. So it can be kind of complicated how the money is flowing to that shareholder, because you're a shareholder plus potentially an employee of the company. And so you're getting some of your income is coming in through the shareholder, through your shares, and some of the money is coming in as an employee. That's a example of complication there. We also have the C corporation. The C corporation is going to be similar to the sub S, where you can simply hold the shares, right? If General Motors is going to be a C corporation, and I'm a shareholder of General Motors, well, I can get paid by dividends. And if I'm paid by dividends, I'm going to report that on my tax return. I'm going to just pay interest on that as you would for a corporate dividend, which is going to be taxed at a lesser extent than, for instance, your employee income is going to get taxed at a greater interest. Now, sure, I can be an employee of General Motors and get paid a salary there and also be a shareholder of General Motors, right? Similar to the sub S corporation. The difference, though, between the C and the S is a C corporation, once that C corporation reports its earnings, its net income, that is going to be taxed at that point inside the corporation. That corporation will actually pay a corporate tax, and then that money will go through and be a dividend to me. Hey, Dan Crane, General Motors shareholder. General Motors paid income itself, its own taxes that it had to pay and then the money flows to me as the shareholder as my dividend, and then I have to pay taxes, and that is termed as double taxation. It's allowed. It's a thing. It's obviously kind of a thing that you would like to avoid, potentially, depending on corporate structure and what your goals are and all those types of things, but that's there. So we need to talk about it. The corporate veil. So we have taxation. Taxation, obviously an important attribute to selecting your form of business, whether an LLC, a sub S, or a C Corp is going to be more advantageous for you. Typically, the LLC is going, well, anyways, I'm not going to get into that, how you would pick one of those. Suffice to say, you want to pick one, and there can be a tax advantage for you selecting the correct one depending on how you're making your money, the amount of money you're making, etc. What's the other really important attribute for most individuals when they're selecting their form of business? And that is going to be the corporate veil, the protection as a legal entity. And here, there's not much difference between the three corporations versus a partnership. A partnership has unlimited liability, which is horrific because you really don't want to have some sort of issue with your business, and your business can't afford to pay that legal debt, and then someone is coming after your house or your car or your IRA, your savings, your etc. You want to keep your personal assets safe. Therefore, you want the corporate veil. So that's pretty obvious. The good thing about the partnership is it's easy, it's fast, the informality is cheap up front because you obviously don't have to hire anyone. You can just do a handshake, whatever. Suddenly now you're a partnership. That part, yeah, correct. It is cheaper and easier to form up front, but that cheapness up front comes with unlimited liability. So we move into the more expensive forms of corporation, I would say, that it's a pretty safe bet. The LLC is going to be the cheapest to form, the sub S, the next cheap, the medium expensive to form, and then the C Corp, the most expensive to form. Also, when you go to pay taxes, typically it's going to be cheaper for your accountant. They're going to charge you less money as a partnership, and it's going to be a little bit more complicated as the LLC, the sub S, the C Corp being more complicated. That's more expensive. Also, the LLC has a little bit less formalities, right? We don't have these minutes, we don't have the annual meeting. The sub S being more complicated and the C Corp being slightly more complicated than that. Because of these extra legal formalities, guess what? You're going to probably have, yes, extra legal fees. And so that's a little more expensive. So those are things to also weigh as well. But the LLC, the sub S, and the C Corp provide you with the same strength of veil. I would like to call it a shield myself. You can even see here in this graphic. Ooh, I thought this wasn't recording my voice for a second there. I was like, oh my gosh. Anyways, this graphic to me is a big circle. It's a shield, and it blocks you from liability. We see the creditors coming in, trying to get to the shareholders, and the shield is blocking it off so the shareholders' personal assets are safe. That's great. Now, even though all three provide the same strength of protection, sometimes because some legal theorists or attorneys would advise that even though an LLC has less formalities, you as the owner need to pay very close hyper attention and focus to the formalities that are within the LLC, because the moment that too many of those formalities are ignored, for instance, let's use a good corporate formality here, that is the business needs to pay its own expenses, and you personally, as a member of the business, need to pay your own expenses. So what you would not want to do is, as my personal DP&L bill comes due for my house, I don't want my LLC's checking account to be sending money straight from my LLC checking account to DP&L. Would not want to do that for my own personal DP&L bill. I'd want to first take a payment from the corporate checking account, transfer that money to my own personal checking account, and then pay my DP&L payment out of my own personal checking account. Seems a bit silly, right? Like, boy, that seems a little extra complicated. Well, that's just how it works. To have this level of protection, it needs to be treated as its own formal, separate entity from the person. If the person in the separate corporation legal entity, the LLC, becomes so intertwined that you can't tell where one ends and the other begins, that protection is going to erode away. Another term or a type of term for a protection that is eroded away would be called a defective corporation. A defective corporation occurs when the corporation is formed. In order to prevent a defective corporation from escaping, this is getting a little bit complicated at this point, but you can misform your corporation. Again, the intertwining, you need to keep the two entities separate. One of the things you need to do is the title of the business needs to alert people that they're dealing with the business. How do you do that? Well, that's at the end of the name. You're going to put something like LLC or limited liability company or incorporated or that type of thing. Alerts people to the fact that when they're dealing with that entity, they're dealing with a separate business and not with the person or the individual. Therefore, you know who you need to deal with in regards to remedying a situation, a breach of contract, that type of thing. All right. So if I form my corporation, but I don't identify it at the end with Inc. or something like that to identify that as a corporation, but I put it all in my articles of organization, and I upload it to the Secretary of State, all those kind of good things to form my corporation, well, my corporation is defective. But people could rely upon my defective corporation, but it's not an entity. As I said, it's defective. There's nothing there, but someone could yet still rely on the fact that they're dealing with an entity, and that entity could potentially have assets, right? I've formed a corporation, even though it's defective, it has a corporate checking account, and there's $10,000 in there. I get sued. Someone is suing my defective corporation. My legal argument in defense could be, hey, you can't sue anything because there's no real entity there. You, in fact, need to sue me personally. Guess what? Haha, my checking account, my personal one, has $5 in it, but my defective entity's checking account has $10,000. Clearly, that's bad. Therefore, we have estoppel, corporation by estoppel, that courts are going to enforce to allow people to go after a defective corporation's assets. Whew, that was getting into some nitty-gritty. Hope you followed that. Shareholders may not be held personally liable for a defective corporation's actions. Again, talking about the defective corporation. Got a defective corporation. Shareholders are going to be liable. So that's bad as regards to the shareholder. Which of the following references the liability of corporations for torts and crimes committed by their agents during the scope of their employment? This is taking you back to agency law. Agency law, principal, agent liability here. Are employers going to be liable for the actions of their employees? Potentially, yes, and this is called respondeat superior, which means look to my master. I'm out there driving my delivery truck and I break a mailbox, something like that, and then the homeowner sues. They can sue me personally, the employee, for my tort of accidentally breaking their mailbox, but they can also look to my master, which is sue my employer for the damages that occurred too, quite likely. Corporate rights. Corporations are a separate entity, and we're talking about the United States right now. Do they have some constitutional rights? They are entitled to the protections of due process, which would be notice and that types of things, a legal proceeding, and equal protection, Fourth Amendment protection against unreasonable search and seizure. Makes sense, right? See that in the movies. You have the warrant. You're coming to the auto body shop because you think there's some illegal car thievery going on there. See how many cop shows I watch. Not very many. They bring their warrant to the body shop. They need a warrant. Why? Because the business has some Fourth Amendment protection against unreasonable search and seizure. And corporations have the First Amendment right, protection for freedom of speech. One of the things a corporation doesn't have, however, is the privilege against self-incrimination, meaning corporations cannot plead the Fifth. Courts have consistently held that corporations have no rights under the U.S. Constitution. That's false. They have some rights. A corporation is a blank corporation of the state in which it was incorporated. That would be home state. You may choose a state to be incorporated in. Delaware would be ranked high for the friendly laws for corporations, so a lot of big or more complex, fancier corporations, etc., are going to file in Delaware. Las Vegas is another one, too, Nevada, I should say. That's another state to file in. My corporations are filed in Ohio, because that's fine for me, so that would be my home state. A blank corporation is a business incorporated in another country. You might be shocked to find out that that would be a foreign corporation. Actually, probably not shocked, but foreign corporation, if that makes it any easier to remember that. Corporate major classifications. Breaking it down into some more classifications here. You can have nonprofit corporations, municipal corporations, professional corporations, and business corporations. What I would like to talk about there is professional corporations. Professional would be attorneys, CPAs, accountants are good examples. A lot of times those will be identified as LLPs, limited liability partnerships, very similar to LLCs, but they are professional organizations. Creations. How do we make them? Well, you're going to need articles of incorporation. I don't know if all 50 states calls them articles of incorporation. Sometimes they're called other things, but in articles of incorporation is a very important set of documents representing the corporate charter, meaning the rules of the corporation and stating how it's coming into existence, what it's coming into existence to do, how long it's going to be around for, who's the initial members, how are we going to pick directors, that kind of stuff. It's all going to be there. How you're going to transfer stocks, those types of things. Some important things articles of incorporation must include the corporation's name and its corporate purpose. Corporate purpose can be broad, but it's going to need to be in there. Which of the following in the corporate formation process provides basic information about the corporation? Well, we were just talking about that, and that is the articles of incorporation. I'm gonna say corporation a lot. If you don't already think that I said it a lot, it makes me feel a little bit like that movie Super Troopers, where they pull over the person and they have the bet about who can say meow more. My goal is to see how many times I can say corporation. Which of the following is an individual who applies to the state for incorporation on behalf of a corporation? I love that. That would be an incorporator. It can also be called a promoter. An incorporator. An incorporator is going to be that person for that moment of time that's incorporating. They're in the process of incorporating that corporation. The articles of incorporation determine who has the power to amend the corporate bylaws. The corporate bylaws are the rules. They're going to be inside the articles of incorporation. Do they have those things in there? Yes, it's true. Corporations are not required to indicate in the name of the corporation that the business is incorporated. False. False. A business needs to identify that it's a separate entity from the shareholders. So you must have some magical letters at the end of the corporate name, like Inc., LLC, that kind of stuff. Corporate. What are rules and regulations that govern the corporation's internal management? Well, you might be shocked to know that is bylaws. Where do we find bylaws? In the Articles of Incorporation. The Articles of Incorporation are going to have rules about how you do stuff with the corporation. And that's called the bylaws. Corporate powers. A corporation has two powers, express powers and implied powers. I love this. When a corporation is acting outside its permissible power, it's said to be acting ultra vires, outside the lines, outside its powers. A corporation engages in ultra vires acts whenever it engages in illegal activities such as criminal acts. All right, let's talk about this express and implied powers. What are express powers? Those are going to be the powers that are going to be listed out expressly in the Articles of Incorporation. What are the implied powers? Those are all the powers not written down, but by reading the express ones, you would need these other implied ones. Similar to, we talked about implied powers before in agency law, where you have the agent acting on behalf of the principal. The principal gives the agent some tasks. Of course, they list down all these tasks, such as go to the store and get bread. That's your job every day. Go to the store and get bread. But they didn't say specifically drive, walk, take a bus. You may leave our place of business to go across the street to get the bread. Those types of things. But it would be implied. It's your job to get the bread. Therefore, you're going to walk, you're going to drive, somehow you're going to go get the bread. That would be an implied power. Corporations have implied powers, true or false? I'm not even going to tell you the answer to that one. Which of the following is a document a corporation files with the state explaining its organization? That would be Articles of Incorporation. If corporations act beyond their express and implied powers, That act is called an ultra vires act. Shareholder powers. Shareholders, they're not going to have too many powers. They're going to have limited ability to affect decisions. Which of the following is generally true regarding the management of a corporation? Shareholders directly participate? No. Shareholders do not elect a board of directors. Wow, that's okay. That's funny. The board of directors selects officers to manage the day-to-day business operations. A corporation has no central management. Well, this is going to be shareholders. One of the things that shareholders can do is they can vote on the board of directors. The board of directors are going to be the ones who are going to select officers that are going to manage the day-to-day business of the corporation. Now, directors can also be officers. That's potential. And shareholders could be a director and an officer. That's possible. Which of the following owns a corporation? If you think it's Facebook friends who like the corporation, you would be wrong. But also awesome for thinking that. It's going to be shareholders. Shareholders own the corporation. Now, in an LLC and a limited liability company, typically shareholders, quote unquote, are going to be called members. But in a sub S corporation and a C corporation, they are going to be called shareholders. Which of the following is used by corporations to distribute their income to shareholders? That's going to be dividends. Shareholders get dividends. Directors. Directors exercise the corporate powers. They must exercise these powers in good faith because they have duties. They've got to oblige by those duties. Certain decisions may be delegated to a committee or to corporate officers. The corporations need at least one director. No qualifications are required, and directors may be removed without cause. Directors, just like shareholders, must regularly meet and may be paid for their involvement on the board. If corporate directors fail to sue when the corporation has been harmed by an individual, another corporation or director or shareholder can file on behalf of the corporation a blank. So this is another one of those minor powers that a shareholder does have. They can do I want to make sure this is the correct question here for shareholders. If corporate directors fail to sue, yeah. This is going to be a shareholder's derivative suit. A shareholder's derivative suit. The shareholder is deriving their power to sue, hence the word derivative, from the fact that they are shareholders of a corporation that has a claim, some type of legal claim, legal cause of action, but for whatever reason, the corporation, the directors, don't pursue that claim or cause of action. And the shareholder thinks, well, my value of my shares, or I might not be getting a big a dividend because they're not initiating this lawsuit. Therefore, the shareholder can sit in the shoes of the corporation, deriving their power to sue on the fact that they are a shareholder. Which of the following are directors who are also officers or employees of a corporation? That would be called inside directors. If you're a director, but you're also an officer or an employee, you're an inside director. Directors and officers have a fiduciary duty of care to act in the best interest of the company. That's true. Directors and officers have a number of fiduciary duties. One of them is the duty of care. Which of the following may a director generally be removed for cause, which means failing to perform a duty? Which of the following is a right of corporate directors? They have all of these rights. They have the right of compensation, the right of participation, the right of inspection, and the right of indemnification. All those things all flow from the corporation to the corporate director. Those are things that the corporate director is owed. But the corporate director also has duties that flow back towards the corporation, with the duty of loyalty, the duty of care. The duty of care is to act prudently as a reasonable business person. The duty of loyalty is to offer up any good deals first to the corporation that the corporation is in that type of business. For instance, the laundromats, my dad and I, small corporation, still counts though. My dad would find another sweet laundromat to buy. He would have to present that offer to me, being the other shareholder of the corporation, in order to allow the corporation to make the decision to perhaps purchase that other laundromat. If the corporation would turn down that offer, then my dad, being the other shareholder, could go and, being the other director, I should say, can go and make that own purchase, form a new corporation, or do it personally, or whatever. In which of the following does a shareholder sue alleging that he has suffered damages by the corporation? This would be a shareholder's direct suit. This is different. The shareholder was directly damaged by the corporation. Shareholder has a direct suit against the corporation. When directors or officers violate their duty of loyalty, they are self-dealing because they're not putting the corporation's best interests above their own. Correct. They need to put the corporation's best interests first. Which of the following are directors who are not officers or employees of the corporation? That's going to be outside directors. If you're a director and not an officer or an employee, you're an outside director. Which of the following occurs when a legal contract combines two or more corporations such that only one corporation continues to exist after that? That's going to be a merger. Two corporations come together. Boom. Only one corporation exists after that. That's called a merger. Shareholders are directly responsible for daily management of corporation. False. They are not. Owners of which of the following types of stock enjoy preferences with respect to assets and dividend? That would be preferred stocks. Preferred stock is better than common stock. If a corporation has two different types of stocks, you can have several different types, but we're talking about the difference between common and preferred. Preferred will have some advantages, some perks, maybe first up right to buy new stock, maybe right to a larger dividend than common stock, that type of thing. Which of the following is generally false regarding the surviving entity in a merger situation? In a merger situation, that's where two corporations are coming together to form only one other corporation. One corporation is going to be the surviving corporation. Their articles of organization are going to stay intact and not be revised. The other corporation that's getting absorbed into the surviving corporation, their articles of incorporation erode away and disappear. Death of a corporation occurs after which of the following two steps or phases? The legal terms here you're looking for is dissolution and liquidation. Dissolution and liquidation is a winding up of the business. It is a resolving of the debts, paying the debts off, and then selling off the assets, liquidating them. That's dissolution and liquidation. A corporation must be dissolved if 50% of the shareholders die. That's false. In a merger situation, which of the following is the term for the remaining corporation, that is the surviving corporation? If you made it to the end, congratulations. Give yourself a giant corporation law high five. Everyone have a good morning, a good afternoon, a good night, wherever you are. Professor Crane signing off.